This is Earl White, real estate attorney. This is a video about understanding quitclaim deeds in New Jersey if you are conveying or transferring ownership of real estate from the grantor, who is the current owner, to the grantee, the new owner, and it's not a traditional sale and you're not promising that they are getting clean ownership free of liens, then you may need to consider using a quitclaim deed. So this video, we're going to dive into what is a quitclaim deed, what is the language we should be using for a quitclaim deed, what are circumstances it's needed for, and what's the process from beginning to end for drafting and recording the quitclaim deed. Okay, let's begin with understanding what is a quitclaim deed. The best way to understand a quitclaim deed is contrasting it against the standard deed that we use in real estate traditional closings. The standard deed in real estate closings is what's called, it has a covenant against grantors. What that means is that the grantor is making a promise that they have done no act to encumber the title, which means that they haven't put a lien on the property that is going to become a problem or a claim by a third party to the real estate after you take ownership. So they haven't done anything like unrecorded deeds, unrecorded mortgages, court judgments that have not been disclosed. There's nothing out there that this owner has taken an action to damage your title. So that's the standard deed, warranty covenant against grantors acts. Now compare that to a quitclaim deed. A quitclaim deed means that the owner is not making any promises whatsoever that you are going to receive clear title, just whatever the title they have, whatever the quality of it is in terms of liens, other claims by third parties, whatever they have, they are transferring that to you without any promises or guarantees, express or implied. And so that is the ownership that they're going to get. Now, New Jersey has a statute that references specific language that should be used when using quitclaim deeds to convey ownership to new grantees. So the sample language here, and here's what should be reflected. The grantor does hereby remiss, release, and quitclaim onto grantee, so that's the new owner, to the grantee's heirs, successors, and assigns forever all right, title, interest, claim, and demand which grantor has in and to the described premises. So whatever ownership they have, that's going to be transferred, and to hold at the same upon grantee and to grantee's successors and assigns forever without any covenant, warranty, or guarantee express or implied. So I think the key language here is that we have remiss, release, quitclaim. So we have the quitclaim language, and then without any covenant, warranty, guarantee, express, or implied. And that language is going to really make clear that you're just giving the new person, that you're just giving the new owner, the grantee, ownership, whatever you have, with no promises relating to liens or any other claims by third parties on the property. So the next question, naturally, since you're using a non-standard deed, is what are the circumstances where an owner would want to use a quitclaim deed in transferring ownership to a new owner? So it can often be used in intrafamily transfers, like mother to son, sibling to sibling, between grandparents. Basically, when we're doing a transfer like this, the parties share a lot of trust. So there may be no need. Now, you certainly could still have them. Particularly, I think it would still be important in that relationship that one party is still making a promise to the other party. But that might be a situation where there's so much trust between each other that for some reasons you want to use the quitclaim language as opposed to the standard language that would reference conveying the property without liens. Another situation is disputed ownership, and this is a time you really should use a quitclaim deed. If you are the owner of a property and there are third-party claims to ownership, perhaps it's through an estate where you took title as administrator, but other heirs are coming out of the woodwork to make claims to the property. Perhaps there's several mortgages that haven't been paid off, and there's been potential foreclosure actions, and perhaps they're being disputed in court. Now you have a lawsuit about the potential interest of third parties about the foreclosure, and if you're conveying title to a third party, that's a time to use a quitclaim deed because you really can't make any promises that the title is clear because it's presently being disputed. You also might have a situation where you're conveying interest to a business entity. Now, So for example, say you are presently an owner as an individual and you want to convey the interest in real estate to a company that either you own or newly created. In this case, you might not need a normal deed because you are basically on both sides of the transaction. You could use a quitclaim deed to avoid any interest or disputes in the future if the company changes, but not mission critical there because it's basically between you and yourself in terms of you as an individual and then an entity that you either own or are part of. Last one, this is important for use of a quitclaim deed, is that if you know there are potential or existing liens on the property, then you want to make sure you have this language for a quitclaim deed, not making any promises or guarantees as to claims, liens, or third party making an attempt at ownership of the property. This examples could be for this: if there's a foreclosure action open, then it's a lien in a lawsuit, and you know that you probably can't convey title in traditional means. In fact, the person probably might be very well aware of this foreclosure, and so you're going to make no promises quitclaim deed in that situation. Similar thing if there's tax liens on the property, that the parties might be aware of this issue, and the grantor is giving it to the grantee, and the grantee might often understand what's going on because people are smart. If they're getting a property for a reduced rate, and typically a quitclaim deed is going to be a highly reduced rate to the market value, they will realize that there's going to be issues with this title, and that might be part of the strategy for using this deed. For example, maybe they're going to pay the legal fees to fight the lawsuit, and that's why you're conveying it to them, because the current owner doesn't have the money or doesn't believe the lawsuit can win, and the grantee, the new owner, maybe has the money or believes the lawsuit can win, or they just want to take a shot at it and get a property at a discount. And if they can win, if they lose relatively low risk because they didn't buy it at a market sale, so they got a big discount. The last thing we'll cover here is what is the process for recording a quitclaim deed. And this is similar to any deed. So here's the process. Step one, either you hire an attorney to craft the deed, or you can create it on your own. In New Jersey, creating a deed for a third party is considered the act of law, and therefore it has to be with narrow exceptions. It has to be an attorney, or if it's for yourself personally, then you do not need an attorney. Obviously, there is a lot of legal considerations that you may have and questions as part of any deed conveyance, so an attorney can make sense. But if you're doing it yourself, DIY, you can draft the deed yourself. Next step is you're going to have to, once the deed's prepared, and there's also supplemental forms. In New Jersey, it's required to have a get rep form, which is a government form that states an exception that there doesn't have to be a 2% withholding that New Jersey otherwise would do. And the exception here would be consideration less than $1,000. Usually there'll be an exception that you have to check in that box. An affidavit of consideration is also required, which states the consideration or the amount of value being exchanged as part of the quitclaim deed in this case. So you've either hired an attorney, drafted the document yourself, you've got all the language in, all the supplementary forms together. Now you need to notarize the document. So in New Jersey, it can't just be that you sign the documents. You have to have it notarized. So there has to be a witness to signing the deed and affidavit of consideration. So the witness can either be a notary public or it can be an attorney. So one of those people have to notarize the deed for it to be in recordable form. Finally, you have all the documents ready. They're all signed. And you submit them for recording to the county. And you could do that via e-recording, you could do that via mail, you could drop it off in person. We always recommend e-recording because it's fast and you don't have any risk of losing the documents because you can hang on to them. So that's what we recommend, typically recorded in less than 30 days.